34 common estate planning traps and how to avoid them. Today in my continuing series on the 34, I'm up to 9. Number 9, attempting to dispose of property in your will that is not part of your estate. So a will is a document that upon your death gets presented to a court of law. In New York, it's called the surrogate's court. And a will can transfer property that is solely in the name of the individual person that passed away, right? The testator of the will. So if a person has a joint bank account, it cannot pass through a will. It will immediately go to the joint holder by operation of law. Similarly, beneficiary designations, financial instruments that have a beneficiary designation cannot be transferred or distributed or dispersed through a will. So if I have a bank account that's a POD or an account in an institution that's a TOD or an ITF, payable on death, transfer on death, in trust for, those items will not pass through a will because they're not part of the probate estate. Number 10, not executing your estate planning documents with the legally required formalities. What does that mean? Well, when you execute a will, whether it's with an attorney that specializes in elder law or estate planning, or if you attempt to do it on your own, a will needs the legal formality of the execution process. And an attorney that deals in this field will have a routine developed so that the person will declare their will, that it's their intention to make a will. You'll have the requisite number of witnesses, and the attorney will make sure that the signer of the will has testamentary capacity, right? That's really a critical component of this. If a person does not have capacity, then they're not legally, really their will not be legally valid, right? So if you would like to speak with me about any issue, please look me up, frankbrunolaw.com. Thank you very much.